We remind you we remind you to please rename yourself with your CISA number and first and last name if you have not had an opportunity to do so yet. This series is brought to you in collaboration between the Wisconsin Department of Public Instruction, the RSN, or the Wisconsin Regional Special
Well,
Education
and
Network,
frankly, I'm not
and
aware of all of the.
WCAS, or the Wisconsin Council of Administrators of Special Services. Just a couple of reminders. If you can have your camera on, then that's a great thing for our speakers so that they can see your faces as they are presenting today. But please remember to mute your mic unless you are speaking with the group. We do have a parking lot that we use for questions. That parking lot is linked in today's agenda. Today's agenda was in your reminder email and it has also been dropped in the chat. And please use the chat to respond to speaker prompts to limit distractions for the speaker and keep us focused on the topics for today. These meetings are recorded and they are available for viewing after the fact. And so for that reason, we ask that we are the only recording today. We will update the agenda. So the agenda that you have available will be updated with timestamps once the recording is posted. So if you're looking to review just a specific topic from the recording, then you will have access to the timestamp for that topic so that you can go directly to that portion of the video. Today, we have a packed agenda. We are going to spend a lot of our time talking about private schools and how we serve students in private schools. We are kicking off today with Helen Leong, who will be here to talk about our special needs scholarship program eligibility requirements. Then we'll take a short break and circle back to that topic of private schools with Paul Sherman from DPI. And finally, a much requested topic, we will have Michael Hickey and Marge Reeson from DPI here to talk about trends and patterns in complaint process. As always, we invite you to set a learning goal for yourself today, a question that you would like answered, something that you would like to focus on and bring back to your school or district. And we hope that everybody, I was just think we're yeah, still just a few more people in the waiting room. And then Helen, do you have slides that you would like us to share, or will you be sharing those today?
Yeah, if I'm allowed to share them, I do have some slides to share.
That sounds great.
I can go
Welcome.
ahead and get that set up for everybody while we're waiting.
Sounds great.
Okay. So just let me know when you want me to start.
I think we're probably good to get rolling.
Okay, great. Well, hello, everyone. My name is Helen Leong. I am the school administration consultant at the Department of Public Instruction for the Special Needs Scholarship Program. This is a small program, so I'm the only consultant for this program at DPI. So when you're working with a private school or a district and they call that 188 number or they email SNSP at DPI, I am the person they're communicating with. So I like to think that makes sure that everybody's getting consistent answers and consistent information for the program and how to do things. So the Special Needs Scholarship Program allows a student with a disability who meets certain eligibility requirements, which we'll go over today, to receive a state-funded scholarship to attend a participating private school. I'll also talk about that a little bit more detail. We're governed by Wisconsin Statute 115.7915 and Wisconsin Administrative Code PI 49. And I do have the web page there available, though that web address may change. It should remain as a forwarding address, but I know our web pages are going to be updated soon. One thing to keep in mind about the special needs scholarship program, so this is not a choice program. So when you hear people talk about choice programs, we are not lumped into them. It is the choice programs and the SNSP. So we are a separate and distinct program for those. So the Milwaukee Parental Choice, Wisconsin Parental Choice, and the Racine Parental Choice programs are governed by different statutes and administrative rules and have a different team of consultants that work for those, and they have a different system, et cetera, et cetera. In 25-26, we have about 3,400 students participating, with a little more than 200 participating private schools, and we affect a little over 200 resident school districts. This program began in 2016, 2017. I like to provide this as just a little bit of context. The choice programs have about 50,000 plus students participating, so we are a very small um, compared to them. But we only come in contact with about half of the school districts in the state of Wisconsin. And these districts can fluctuate from year to year because we may only have one student in a district and then they're not there the next year, but then a different district comes in contact with us for the first time. So I know that as the program grows, I'm coming in contact with more and more districts each year. So, which schools participate in the special needs scholarship program? So, if you want to know whether or not you have private schools within your district that are participating in the program, it is a unique list from year to year. So, that is available on our 25-26 student application and transfer request page. So, I've kind of got a little screenshot there of the left hand menu from our webpage that shows you where you can go to find that current list of schools. In order to participate in this program, private schools do have to register to participate annually. So it is an annual process that they start. It starts later than the choice program, so they initially submit their intent to participate in late February to try to meet a March deadline, and that's when our registration process starts. This this list of participating schools is typically updated in June each year for the following school year. So, how do students apply to this program? So, this is another unique aspect of the program as compared to the choice programs. We actually have a paper application that families can download and submit, and then the private school processes the application. So the family provides that paper application directly to the private school they're interested in attending, and then the private school processes that application. And then once that application is determined eligible, the private school submits the data. We now have a WISE application for the private schools to use. It is not connected to the other WISE data processes. It is separate and distinct application for the private schools, and then they submit that data to us. All SNSP applications are audited by independent third-party auditors following each count date. So, in twice a year, all of their applications are audited for any new applications that have come in. So, what are the eligibility criteria for the special needs scholarship program? So, a student must be a Wisconsin resident, and they must either have one, an IEP or a services plan that is currently being implemented, or an IEP or services plan that was developed no earlier than 3 years prior to September 15 of the school term and have not been subsequently determined to no longer have a disability. These are the eligibility criteria for the SNSP. Please note that an evaluation that determined a student has a disability is not sufficient to meet these eligibility criteria. The student must have an IEP or a services plan that was developed to meet these initial eligibility criteria. SNSP students are parentally placed private school students, so it does not alter IDEA requirements regarding the identification, evaluation, and provision of services to parentally placed private school students. If the student is found to be a student with a disability, then the district may determine whether or not to make an offer of a services plan. If the parent plans to apply for the SNSP for their child and the district declines to make an offer of a services plan, then the parent is advised to request an IEP be developed by the resident school district. So if a parent calls me, this is the information that I provide for the parent. And if a private school calls me, this is the answer that I provide to the private school. If a parent requests it, the resident school district must complete an evaluation to determine if a student has a disability, if the student has a disability that would qualify the student for an IEP, and the parent requests that an IEP be developed, the resident school district must develop an IEP for the student. So this language right here is available in that document that I have the screenshot for on this page. So that is that SNSP frequently asked questions for public school districts. I did not put in my notes what number question it is, but I believe it's 17. So if you are trying to look for that language or provide that language as assistance to a district or a private school that has contacted you, that is where you would find that. The non-resident district would not develop an IEP for a non-resident student. If the non-resident school district completed the evaluation, the resident school district may adopt the evaluation completed by the non-resident school district, and the request for the resident school district to develop an IEP should come from the parent.
Helen, there is a question in the chat. Would you like to take that now or at the end?
Sure.
Yeah,
I
it
didn't see it.
says IEP and service plan current or within 3 years. Does that mean that every 3 years a service plan or an IEP needs to be updated?
No, the 3 years is for those reevaluations. So if the student is already participating in the SNSP and they've met the initial eligibility criteria, then we just make sure that those students continue on that 3-year reevaluation schedule. So, but if you're reevaluating a student, they don't need to have a new IEP developed after that reevaluation. And the services plan would always be contingent upon the district's policies and procedures to determine whether or not a services plan would be extended to that student. So those don't need to be re-upped. The one situation where that would be different is if, let's say, the family is not currently participating in the special needs scholarship program, and so they do want to now apply, but they were previously evaluated. They may, on that 3-year reevaluation, then ask for that IEP because at that time they're then thinking about applying for the SNSP. But for continuing SNSP eligibility, there's no annual updates to an IEP. There's no need for a new IEP following a 3-year reevaluation. And again, those services plans would just be contingent upon the district's policies and procedures. Okay. So I do want to talk a little bit about where specifically LEAs that prepare these IEPs and develop these IEPs and services plans get pulled into the SNSP process. So under the SNSP, verification that the student meets the eligibility criteria is actually completed by the LEA that developed that IEP or services plan. So the private school will send an email and it looks like this. The one I provided to you is our template that's available on our webpage. So it will include the student name, date of birth, the date application received, and I'll talk a little bit more about why that matters in a few minutes. Whether the student is a resident of the LEA. So there is actually a separate email that goes out if the student, the LEA did not develop the IEP or services plan for that student's eligibility, but they just live within that district. There is a separate notification email just to let you know that a student that lives in that resident school district has applied for the program. And then the private school that the student is applying to. So the LEA verification email will look something like this, and it will ask the district to determine whether or not the IEP or services plan meets that eligibility criteria. And I'm going to talk a little bit more in detail about that criteria in a few minutes. And then the LEA, in order to say, yes, the student meets these eligibility criteria, would reply to this email and attach the student's IEP or services plan. Sometimes we get questions about whether or not the district needs a release of records from the parents prior to responding to this email. So I did just want to point out that on the SNSP application itself, it actually includes a release of records related to documentation related to this application. So the parent does release those records as part of their application for the SNSP.
There is another question in the chat. It says, if a student was evaluated and found eligible as specific learning disability while attending a private school within a resident district, however, the IEP was never developed because the student didn't plan to enroll in private school, nor did the parent request one. This school year, they applied for SNSP at a private school in a non-resident district. Because there was no IEP in place prior to 9/15, they would not be eligible, correct?
Um, let me, is everyone else hearing that echo?
Do I have to?
Okay, it's better now. Let me come back to this in just a minute because I'm going to talk through that eligibility criteria related to that 3-year look back. So I'm going to just, if you don't mind, just put a quick pause on this question, and then we'll come back to it. Because as I'm showing you this release of records, I did want to point out one other thing that the application itself addresses. So the SNSP application that parents complete, pages 2 and 3 are the comparison of rights of students with disabilities and their families under state and federal special education law and under the Wisconsin Special Needs Scholarship Program. You got to take a breath in between trying to say the title of that document. So I just wanted to let you know that that was there. So in case you have a family or a school or a district that's trying to clarify what the parents have been informed of as related to their rights. That can be a helpful document for you. So that is pages 2 and 3 of the SNSP application. And when parents apply, they do initial that they've received that. So that's part of what you see up here on the screen is where the parents initial that they've received pages 2 and 3 of the application. But that can be a helpful reference point when you're working with families that don't maybe have questions about how this program relates to their what they can and may be offered from the district. Okay, so let's go back to that eligibility criteria like we were just talking about. So this is actually the same slide that I had up earlier. I'm just repeating it because I just think it's helpful to kind of do a touch base on this. So that September 15th, 3 years prior to September 15th of the school term. So it is a 3-year look back. So each year for that eligibility criteria, it does change slightly because we look back for 3 years, whether they had an IEP developed within the last 3 years. And then September 15th is sort of our cutoff date for each school year. So if the student never had an IEP developed, then they would not meet the eligibility criteria. Or if they don't have a services plan. So if you have a student, private school student who's attending in a non-resident district in a private school there, they might have a services plan from the non-resident school district. I just don't know. So if that resident school district is getting an LEA verification email for a student who was evaluated 3 years ago, determined to have a disability, but the parents never requested an IEP and they never developed one, then their response to that LEA verification email would be that the student does not meet the SNSP eligibility criteria. And then at that time, the parents may request an IEP be developed, and then the resident district can take that where it decides it needs to. But just keep in mind for the purposes of this developed the IEP, if an IEP is expired, it's lapsed, it's inactive, that doesn't matter. We're talking about whether an IEP was developed. So, and that would meet the eligibility criteria. So it's that 3-year look back. And then if the student has since been reevaluated and determined to no longer have a disability, then they would not meet that eligibility criteria. So that's that second prong that you see available up on that screen. So if the parents request an IEP be developed, but it happens after 9/15, are they still eligible? So the SNSP is unique and different from the choice programs. So for this program, students can apply to enter the program at any time during the school year. So if they get an IEP developed today, they could apply for the special needs scholarship program tomorrow. And then they could enter the special needs scholarship program, and then they would be there on the next available count date, which is the second Friday in January. So payments are ultimately based on count dates, just like any other district or school. But they can enter the program and leave the program at any time during the school year. We don't have the same rigid application periods that you see with the choice programs. So that's one of the unique aspects of this program. So, what is not sufficient to meet the SNSP eligibility? So, a draft IEP is not sufficient to meet the SNSP eligibility criteria. The IEP does need to be developed, and a draft IEP is not sufficient. An evaluation alone is not sufficient to meet the eligibility criteria. The student must have had an IEP or a services plan developed. A 504 plan does not meet the eligibility criteria. If a student was evaluated, but the IEP or services plan has not yet been developed, then the student is not eligible for the SNSP. If an IEP or services plan is developed at a later date, the family can reapply for the SNSP once that student is available. So that date application received in that LEA verification email is what you're looking for. So sometimes I talk to families who go to an IEP team meeting and they said, okay, we're going to develop an IEP for you. We'll get it to you in a couple of weeks. And then the parents that same day apply for the special needs scholarship program. They're not eligible as of that date application received, and the student must be eligible as of the date application received. So that application would be ineligible, but then once or if that student becomes eligible in the future, the family can apply at that time. So we do look at these based on the application itself, not necessarily the student. It's not that a student is ineligible for their whole life. It's just that that point in time, they're not eligible for the program. Because I think, as we all know, students can have a disability and then maybe they don't have a disability in the future, and that can change throughout their K through 12 educational career. Um, so what are private schools required to do? So SNSP schools are required to implement the IEP or services plan of SNSP students as modified by agreement between the private school and the student's parent or guardian. This agreement must be signed and dated by the parent or guardian and the school. If it is not signed by count dates, the student will not be eligible for all SNSP payments. So they have that IEP developed. The private school and the parents then sit down and develop what services the student will receive while they're attending the private school, and then that is signed by the school and the parent. So in our program, we call this an agreement of services. I work really hard to try to get private schools to not call those agreements services plans, but you will hear that confusion occasionally between private schools and districts and parents. But we do try to get them to call them something else. But for the purposes of the SNSP, when I'm talking to schools, families, districts, I always refer to them as agreements of service. A resident district may request that a participating private school provide it with records relating to the implementation of a student's agreement of services. So the private school must provide the resident school district with that requested record within 5 days of receiving the request. This doesn't come up very often. A private school may not be familiar with this if a district you know does make such a request, but you can always feel free to bring me into the conversation and I can help make sure that that's getting complied with. Okay, so what are the kinds of questions that districts might get related to the SNSP? So one of them to keep in mind is the application itself does ask for the date of the last evaluation. So, and we do track that most recent evaluation. This is not always clear from the paperwork, and I always tell private schools and families, like if you're not sure what the student's last evaluation date is, just ask the district. So that's a common question that you might get from private schools or families that are trying to complete their SNSP application is what is the date of the student's most recent evaluation? And then I kind of track that on my end just to try to make sure that these students are getting their 3-year reevaluations. So um, if you if it goes too long, I will reach out to the private school. So you may get a request saying, "Hey, this student hasn't had a 3-year reevaluation, and they're due up for it." So that's just the kind of requests that you might see come through related to a student who's participating in the SNSP. And that could come from the private school saying, we just need to get this 3-year reevaluation completed. SNSP students are parentally placed private school students for the purposes of IDEA. So IDEA requirements for parentally placed private school students require that reevaluations are completed every 3 years from the last reevaluation date. Participation in the SNSP does require parents to make their children available for 3-year reevaluations. So if the parent ignores a request for a 3-year reevaluation or declines to make their child available, they then are no longer eligible for the SNSP. So that is one of the requirements of participating in the program. If the district and the child's parents agree, the requirement for the reevaluation can be waived. Um, so those waivers are still allowed under the SNSP. That is okay. Sometimes people think they have to do the 3-year reevaluation because the students in the SNSP. No, it's fine. You can waive it if you feel like that child continues to be a child with a disability. It's just the way that it gets reported to us is we count that waiver as that student's 3-year reevaluation and that they are continuing to be a student with a disability. So that was how we would think of it and how we would see it reported on our end. IDEA does place the responsibility on the district where the private school is located. If a parent requests a reevaluation from the resident school district, the resident school district should conduct the reevaluation. And then we don't require that resident school districts develop a new IEP following a 3-year reevaluation. So, and all of this information is again available in that frequently asked questions for public school districts. That is available on our student application page. And it is also available on each specific year. We do review that every year and update it as needed. And then I have here a couple of other places if you want to look for information. The private school vouchers webpage that kind of shows you the impact of the program. Then we also have information available on our payments webpage if you're looking to see what kinds of, what the amounts are for the 25-26 school year. Those are available there. And then that data and reports webpage has the schools that are participating, how many students they have participating, the percentage of their student body that's in the SNSP. We have larger spreadsheets as well that talk about all the choice programs and the SNSP that are available on that webpage as well. So that's all I had. Are there
We have
any
a,
other questions?
yeah, there's a couple more questions in the parking lot.
Okay.
So one is, will you be sharing this slide deck so that we can link it into the agenda after the fact? That's the easy one, maybe.
Yeah, I mean it's part of the recording, so you'll have it as part of the recording. I do like to send people to our resources that we regularly update because things can change very quickly. I don't put these slides available publicly because I won't be coming back and updating them. But the resources that I've talked about today in the presentation, and you'll have it available for you to review as part of this recording. Those are all updated and reviewed on an annual basis. So I really would encourage you to try to use the resources on the webpage to make sure you're getting the most current and up-to-date information.
Okay. The next one says, can public schools have access to the agreements? Can private schools add services beyond what was developed in the IEP? And how would this impact actual cost reimbursement?
Oh, there's a lot there. Okay, so yes, if the resident school district wants to know that agreement, you can request it from the private school. So that is part of that releasing records. Let me see. Can I go back? No. Um, so that is part of that requesting records. I'm going to try to pull that up. Yeah, here we go. Um, It's 115.79156H2 in case you're interested. It is also available on our frequently asked questions. So you can relate it, you can request that information related to the implementation of the student's IEP or services plan and agreement of services, and that would get you a copy of that agreement of services. They'd probably send you all the quarterly progress reports too, so it'd be sort of a bigger request than just the agreement of services. But I really encourage districts to always have good relationships with those private schools, but so they should be able to provide you that information. If they say, "Do I have to?" You can always just send them to me. So I think that was part one of the question, and then there was a question about having services that go beyond what's in the IEP or services
Yeah.
plan. Absolutely, parents can request that. And if the private school provides it, then that would be part of that agreement of services. Whenever I talk to parents, often, maybe not oftentimes, but sometimes when I talk to parents, there are services they're looking for that go beyond what was provided for in their IEP, or they're looking for something sort of specific. So I always encourage them to have that discussion with the private school. And so the private school can provide services and accommodations that go beyond what the student might have been outlined in the student's IEP. Because some of these students also just have services plans. Those services plans are often typically limited. So you might think about like a child that gets speech language services via a services plan, and that qualifies them for the SNSP, but they have other needs that go beyond those speech language services. So that agreement of services might outline those additional things that the private school would provide that are beyond what the services plan would provide. Um, and then you asked about statements of actual cost. Exactly was the question for statements of actual
It
cost?
said, it was referring to the additional services and it said, how does this impact actual cost reimbursement?
Yeah, so just to be kind of specific here, so an actual cost is not a reimbursement program. So a statement of actual cost, just for everybody to be aware, is where a private school submits information related to that student's services from the prior school year. And I'm working on trying to pull up a page where we talk about this in a little more detail. Um, and then we use those expenses related to that prior school year to set the payment rate for the new school year. So for example, we are just entering the 25-26 school year. So we have students whose 25-26 payment rate is based on the actual cost to serve that student in the 24-25 school year. So this is a very small subset of our SNSP students, and you can see those numbers of the total numbers in the state of Wisconsin that are on a statement of actual cost on our data and reports webpage. Um, so in order to receive, and there is a question number 3 on our payments page. So if you go to SNSP, this left hand, push on school information, this submenu pops up in this payments page. Can people see this?
Yes, we can see it.
Okay, great. I just wanted to make sure it was still sharing the screen and not just that one slide deck. Okay. Um, so the the statement of actual cost, in order for a cost to be included in that, it had to be on the student's agreement of services for that school year where that service was provided. So, yes, there may be services that go beyond the IEP that was developed, and that was the basis of that student's eligibility for the initial eligibility for the SNSP, but it would be in that agreement of services, and the private school and the parent would have agreed to that and signed and dated that agreement. And then those services are used to set the payment rate for the next school year. Did that make sense? Or do people want me to try to say that again? Because I know it's not an easy thing to understand.
I I'm noticing that we still have questions rolling into the parking lot and we're at our
Okay.
time. I'm wondering, do you have access to the parking lot? Would you like to type right in there? Would you like us to send you those and then we can paste your answers back in?
Y-
Um,
yeah, I don't know where the parking lot is. So,
okay,
yeah.
we will send you the questions and then we'll get your answers once you respond back into the parking lot, if
Okay.
that's okay. I
That sounds great.
appreciate your time. Thank you so much. This is really helpful and definitely a needed topic with all the questions that are rolling in.
All right. Thank you.
Thank you. Have a great day.
You too.
All right. We are going to take a quick break and we will return. We'll return at 10:45. Little breather there, and ready to circle back into some conversation about private schools. As we mentioned at the end of Helen's presentation, we will get to her the questions that continue to roll in the parking lot. And once we have received answers to those, we will add those into the parking lot as well. So check back there if you added a question or if you're still adding a question. I see people still typing. Check back there to get your answers to those questions. But staying on this topic of private schools, we have Paul Sherman from DPI joining us. Paul, do you have slides you would like to share with the group?
I don't. I'm just going to talk at you like a college professor, and you have to take your own notes. So
That sounds great. Welcome, Paul.
thank you. Well, good morning, everybody. It's good to be here. Um, when I was asked to join you today, the kind of broad topic that I was given was talk about referrals and evaluations for private school students. So that's what I'm going to do. Helen kind of answered some of the questions for us today in her very good presentation. So um, I'm going to just outline a few basics for you. I'm going to walk through some scenarios with you, and then I'll be open to having questions from you if you want to go down a particular road in the time we have remaining. We can do that as well. Um, so basic thing to remember is that your child find obligation um, is the same for your public school students as it is for your private school students. The regulations are very clear about that. The kind of child find activities that you do for your regular students, you have to include private school students in those activities. The evaluation process you use for public school students has to be the same evaluation process that you use for students who are enrolled in private schools. So that's kind of our overarching obligation. And in fact, those of you who are thinking a little bit ahead in terms of, is your equitable services set aside for your private school students, right? We know that our child find, our evaluation activities aren't included in that set aside fund because the child find and evaluation are really a universal obligation. They don't just apply to the parentally placed private school students or just the public school student. So when we think about the idea requirements around parentally placed private school students, the first thing to understand is that the child has to be enrolled in a private school. Okay, so that's a school operated by a private entity. It needs to meet the definition of school that's in the Wisconsin statutes, which basically means school is 4K and up. All right. It's a graded school, 4K through 12. Um, and the program has to have uh, a, an educational component with a progressive sequential curriculum. It needs to look like a school. It needs to quack like a duck. Um, so sometimes we get a little confused. Well, is a residential care center a private school? Generally not, right? Because it's not a school. It doesn't operate an educational program with, sequential curriculum. Some of them do, but not all of them do. The day treatment facilities, right, are you generally about um, mental health treatment, and generally don't operate as a school. Most often, you will be able to identify what a private school is because it's listed in the DPI private school directory. The private schools file a report with us annually and say, hey, we're out here, we're a private school, we meet all the requirements set statute, and that's how you identify whether a particular institution is a private school or not. Um, there are a few exceptions to that. Maybe you live in a district where you've got an Amish or a Mennonite school operating. Oftentimes, those folks are not interested in participating in government bureaucracy in any way, shape, or form, so they don't file um, the uh, the paperwork, but they are still operating in a way that meets the definition of a private school. And you should be aware that you probably have child find obligations to students who are attending an Amish or a Mennonite school, even though they may not be listed in the DPI directory. Um, Oftentimes they don't want to participate in the child find process, and that's fine. It's not your obligation to make them. But if a parent or the representatives of those schools come forward and says, we believe we have a child who is in need of an evaluation and they're attending that school, which is located in your district, your child find obligation applies to that student. In Wisconsin, um, students who are participating in home-based education programs are not considered to be in a private school. That's not a school under our definition. You still need to do child find for those kids, but the rest of the IDEA equitable services participation does not apply to those students. So eventually, if found eligible, they're not going to be receiving services through a service plan, and they're not entitled to FAPE either. So they don't get IEP services. They're in that home-based program. It's totally up to the parents what goes on with that student. Parent might be interested in knowing that the student has a disability that meets the IDEA requirement, so they're entitled to an evaluation just like any other child who might be a resident of your district. But beyond that, that's kind of where your IDEA obligations end for that student. All right. Also important to remember when we're talking about private school referrals is that the child has to be enrolled in the private school by their parent. They're parentally placed at the private school. Occasionally, public schools will have an IEP team, and the IEP team places the student at a private school. In that case, the student remains eligible for FAPE, and you're treating that student just like you do any other student who's enrolled in your district. That's not the kind of private schools we're talking about today. We're talking about where the parent has placed the student in the private school. So the child find obligation, the obligation to include children in child find activities, to accept referrals for children in private schools, to conduct evaluations for students in private schools, generally applies to the LEA where the private school is located, right? That is the general rule. That's the rule that's expressed in the IDEA regulation. So with that in mind, let's go forward and look at some examples. So I'm thinking about an 8th grade student who lives in District A. This 8th grade student is enrolled by their parent in a private school located in District B. So as a general matter, which district is responsible for accepting the referral and conducting the evaluation for this 8th grade student? And you can just write that down on a piece of paper, or you can put it in the chat, whatever you'd like to do. Anybody want to speak up and tell me what the answer is? District B is correct. Yes. So District B, this is just pretty typical the way it works, right? The student is in attending a private school located within the geographic boundaries of District B. District B is going to one who's the district who's got the child find responsibility. Okay. All right. We have a 3-year-old student who lives in District A, and they attend a program operated by a private school in District B. Who has the child find responsibility for the 3-year-old student? I see some District A's. Yep, yep. It's District A because this student is not in 4K through 12. They're 3 years old. So essentially they are not in school. So their resident district is got the child find obligation, and this student is actually entitled to FAPE if they're found eligible. In other words, District A would be developing an IEP for that student. Even though the 3-year-old program might be operated by a private school, they're still considered not to be enrolled in private school because they're not in a 4K program. Now, exception here would be is if this private school in District B, by its own rules, has admitted this 3-year-old student to their 4K program, right? And we don't have anything to say about that. If that district wants to admit 3-year-olds to their 4K private school, wants to admit 3-year-olds to their 4K program, doesn't matter what our public school rules are about age of admission to 4K program. If they're in the 4K program, then their parents have placed that child in a private school. And if that's the case, then District B becomes responsible for the child find for that student because that's where that child's private school is located. Okay. Next one. A 5th grade student lives in District A. They are enrolled in a virtual private school located in District B. Because it's a virtual school, they're essentially sitting in District A getting all of their education, but they're enrolled in this virtual private school located in District B. Which district has the child find evaluation responsibility for our 5th grade student? I see a few B's, I see an A. B is the correct answer, right? Um, we made a determination a few years ago when we first got our first essentially virtual private school, that we would continue to operate consistent with the regulations, which say that where the private school is located, okay? And that the headquarters of the private school is in District B. So District B remains the LEA responsible for child find, even though the student never leaves District A to receive their education, because the program itself is located in District B. District B becomes responsible for the child find. Now, you might ask me, well, how does that work? Because the virtual private school I'm thinking of, and I think it's the only one still at this point, is located in Milwaukee. What if the child lives in the Superior School District? How on earth is that going to work? Well, Milwaukee has to figure out how they're going to make that work, essentially. And it might involve asking Superior to do some of the evaluation activities for Milwaukee rather than Milwaukee having to send staff up to Superior. Superior doesn't have to do that. But if they want to, they can. They would also be within their rights to say to Milwaukee, happy to do that testing for you and those observations for you, but you're going to have to write us a check, and here's how much money we would like to be reimbursed for doing that activity. So, all right. Our next student is a 12th grader. They live in District A and they attend a private school in Marquette, Michigan. Which district has the child find responsibility for that student? I'm not seeing any answers pop in there with this one. All right, it's actually Marquette, Michigan would be the school district that has the responsibility for the child find. The issue of where the district is located has no respect for state borders, right? It applies across state borders. And of course, the inverse of that situation is some of you who work in districts that are on the borders with Minnesota, Michigan, Illinois, or Iowa may have students who live in that state, but they cross the river or the border or whatever to come to a private school located within your district. Even though they don't even live in Wisconsin, you still have the child find the evaluation responsibility for those students who are attending private schools located within the boundaries of your LEA. All right, let's first grade student lives in District A and attends a private school located in District B. And I saw this question already popped into the chat earlier on. However, in this case, the parent has requested that District A conduct the evaluation. Which district is responsible for the evaluation in that situation? And B seems to be the general consensus, and I tricked you on this one. It's actually A. The regulations are very clear that it's the district where the private school is located has the responsibility. But then about 15 years ago, OSEP put out some guidance. And in fact, if you look at the OSEP question and answers on serving students attending private schools, which is posted on our private school page in the special education information, they issued some guidance saying, yeah, that's what the regulations say, but we need to respect parental choice. And if the parents choose to request their district of residence to conduct an evaluation, the district of residence has to do that. And their guidance kind of hedges and says, well, we don't think that's a good idea. But because of the parents' rights and their residency, the district has to do that. And then, in fact, they said, um, then the parent could actually request that District B conduct the evaluation. So you could have two simultaneous evaluations going on for the same student. That's that the answer would be A, unless the parent also requested that District B conduct an evaluation, in which case the answer would be both. I saw that question pop in about the virtual private school. Yes. In our example where we had the virtual private school located in Milwaukee, but the student lives in Superior, that parent would have the right to request Superior to conduct an evaluation, and a Superior would have to complete that evaluation. And in that case, the expense would be all on Superior. They couldn't try to have Milwaukee pay for that because that was being done at the parent's request. Okay, so if you think about this a little bit, this is the reason that Helen gave some of the answers she did with respect to students participating in the special needs program, because if parents want to have an IEP to take to the private school, right, and they don't live in the district where the private school is located, um, the you have to live in a district in order to be entitled to FAPE from that district. And so only that district really has an obligation to develop an IEP for you. And this whole parental choice thing that OSEP threw into the mix of the private school rules is why we have that guidance that says, well, if the parents want an IEP, they have a right to go to their resident district and ask for an IEP. And it kind of is in alignment with that, the guidance about their choice of who does the evaluation as well. Okay, so um, and that kind of analysis applies whether they're in the SNSP, whether they're participating in one of the choice programs like the Milwaukee Parental Choice Program or one of the other choice programs that's available in other areas of the state. There's still, those kids are parentally placed private school students, and the general rules apply, and also that exception for parental choice applies to those students. So SNSP and the choice programs, same thing. Okay. We had an interesting situation come up just last week where we had an independent charter school, and the independent charter school actually had like a, a childcare program attached to it. So they were providing childcare to a student who was 2.5 years old and had been receiving birth to three services. And the birth to three made the referral to the LEA in which the student resides. And the independent charter school said, but we have FAPE responsibility, right? Because we're an LEA just like any other LEA. Problem is that the independent charter school doesn't have a geographic entity that it is, right? It just exists. It doesn't have borders, right? And also, they only have responsibility as an LEA to children who are 3 years old and older. So because this was an issue of a referral from birth to three, and you have to conduct that evaluation prior to the child's third birthday so that you can have an IEP in place on the third birthday, the answer there was actually the referral was correctly made to the child's district of residence. And if the independent charter school continues to serve the student and wants to provide FAPE for the student, they can adopt the IEP once it's developed and the child is past their third birthday. The district in which the independent charter school was located also got into and they were like, well, what are we supposed to do? Do we treat this like a parentally placed private school student where we have the referral and evaluation obligation because of where the charter school is located? The answer to that was no, because the charter school is not private school. The child is not parentally placed. The charter school is a public school. So if that's not enough to give you a headache on this Wednesday morning, I don't know what is, but that's so it just illustrates that it's important to always keep in mind the status of the student. Are they a private school student? Are they parentally placed? And then then pick the rules that flow from what the status of the student is. So are there any questions about that? And it looks like I've got about 3 minutes left.
Paul, I'm wondering
Any other
about the
things about private
question in the
schools? Yeah.
chat
Mhm.
that was referring to when a parent has both requested the resident district do the eval and
Mhm.
District B do the eval. The question was, in that type of a situation, can districts coordinate the evaluation process or must they conduct them separately?
I think OSEP would probably say you need to do them separately because the parent must have a reason for wanting to, maybe they don't trust either one of you. They're trying to keep you honest and they want, so they want two separate evaluations. Um, so I mean, certainly you could coordinate with each other with the parents' consent, but you would not be able to just start talking to the other district without getting the parents' consent first.
There's also a question in the chat about consortium charter school. So,
Yes,
yeah.
that and that's not that has nothing to do with what I've been talking about, right? So um, the the consortium charter has its own rules about um, you know um, and I think that I can't remember the name of that off the top of my head, right? But they take students from non-consortium schools and they also take students from consortium schools. And they have their own rules about who's responsible for the child find and IEP development in that situation. But that those that those charter schools are LEAs, they're district sponsored LEAs. So what I've been talking about today does not apply to that situation at all.
And Paul, there's one more in the parking lot.
Okay.
And I think you started to talk about it or talked about it a bit, but it said if determining child find is assigned by the district of private school location, does the IEP development offer come from the district of residence or the district of the private school location?
Right. So only the district of residence can offer an IEP because the IEP you're offering is based on what goes on in your schools and it's written to be implemented in your schools, which might be a totally different situation from the district where the private school is located. So only the district of residence is responsible for developing an IEP if requested.
Thank you.
Thank you so much for that information,
You're
Paul.
welcome.
And
You're welcome.
we appreciate you joining us.
Yeah, it was good to be
Yes.
here today. And as always, please feel free to call me. I'm still taking calls on this kind of stuff, have been for 18 years. And I'm happy to talk to you individually if you get in a sticky situation or you just were like, I don't know what the hell you were talking about today. Could you explain this to me? It's absolutely fine with me. So,
Okay.
okay.
Thank you so much. Have a
You're
great
welcome.
day.
Bye-bye.
Yep. Bye. All right. Finally, today we are inviting Michael Hickey and Marge Reeson to our stage here. Are there slides that you would like to share?
Sure. I can just share my screen if you want.
Sure. That would be great.
And
Welcome.
our slides are not, this is by no means a hard and fast agenda that we need to stick to. So questions and all of those sort of things are very, very welcome. Okay. Can I do this? Let's see. Do you see my slide?
Yep, you're good.
Yep, we do.
So cool. Okay. So Mike and I are here today. And Mike, you're here, right?
Yep. I had an internet issue. I just logged back in. Can you hear me?
Awesome. Yep.
Okay,
Good.
perfect.
Good.
Sorry, buddy.
We're here. We were asked to talk about kind of the complaint process and some trends and things. So what I've got here is sort of a smorgasbord of things. And again, we're happy to take questions on this for sure. What we've got for the slides here, I wanted to just highlight the fact that there are multiple dispute resolution options under IDEA available to parents. And this handout is on our website. So if you would like to have access to that, we can always send it to you. But IEP facilitation and mediation are definitely good options for dispute resolution. And I can't say enough that you don't have to wait for a problem to get so bad that it's intractable before you proceed with looking for IEP facilitation or mediation. You don't. Getting involved early is really a good idea. And so know that those are available to all districts statewide, no cost to the district. Really could be a tool for problem solving earlier rather than later. So let's not forget about those. What we're going to primarily talk about is IDEA state complaints, which anybody can file a complaint. When the complaint gets filed, it gets filed directly with us at DPI. Paul, Mike, there's a group of us that are complaint investigators, and we do other things too, but we are complaint investigators. So when the complaint comes in, if it's actually a complaint, sometimes we get things that are, you know, kind of like maybe they're really more of a 504 complaint, or it's not really about special ed or something like that. Those we can't accept as complaints. But if it's even possibly an issue that could fall under IDEA or Wisconsin special ed law, even possibly, it's something we need to investigate. We can't say, no, we don't think that's possible. Or, you know, sometimes we get requests from districts to dismiss. That's not something we can do in our process, and we'll talk more about what happens. But that IDEA state complaint is all through us, and kind of the deciders are us as DPI. We're basically going to collect all the information. We're going to look into things. We're going to try to figure out what is the most credible version of the facts. And then based upon those findings, we then will render our answer and whether that's a violation. So we'll talk more about that too. That I want to just lay out as opposed to a due process hearing request, which is the last circle here on this page. And that is a written request for a hearing, and it's about anything, you know, again, it's limited to IDEA issues, and it needs to be, it's much more of an adversarial kind of process. So whereas we say the IDEA state complaint process is investigationary, I don't know if that's a word, but it's investigative. There, how's that? The due process hearing request is different. A due process hearing, should the request progress all the way to the actual hearing, is a situation where the parties are going to perhaps bring witnesses. The person who's filing the complaint, that party bears the burden of proof. You have to prove your case to the ALJ. So it's not about the ALJ doing an investigation and making the decision. They're going to base their information or their decision based upon the information that the parties provide.
And just really quickly, an ALJ
Yep.
is an administrative law judge.
Thank you.
That
Yeah.
acronym. Yep, go for it.
Yep. So we get those hearings. The request, my earring just fell out. That's funny. So I'm a one earring person right now. That's just the way it goes. The requests come to us at DPI. We receive those requests, but once we get them, we process them and send them along to the Department of Hearing and Appeals, which is where those administrative law judges are situated. And really, they manage the process at that point. We're not super involved in the process itself for due process hearings once it goes to the ALJ. So those are all four available. We'll talk a lot about complaints, but there are other options than complaints, and that's just kind of important to keep that in mind. These are these slides kind of talk about the differences between the process. And again, I think we'll make these slides available to Erin so that you can have them, but it's an interesting way to think about what happens when these processes are initiated. You can kind of see the difference here. So a facilitated IEP team meeting, you contact WSCMS, and then again, you can see an IEP team meeting, the outcome is an IEP, right? The resolution is an IEP will be developed. Mediation is a little different. Mediation, again, you contact WSEMS, And that request can come in either individually or jointly. So sometimes when a parent, for example, files an IDEA complaint, districts should feel free to, and we would encourage them to contact the parent to talk through what's going on and say, well, maybe we could try to solve this problem through mediation. You've got more control over the outcome through mediation, because mediation is about the parties coming together with the help of a neutral third party to craft an agreement if possible. Doesn't always work, and that's okay too. But if it is reached, the agreement is something that the family and the school district, you decide what it is, you decide what's how it all goes, and enforcement of that contract basically is what you end up with as a contract. Really depends on both parties kind of buying into it in the first place. And if there's a problem, that would go, they'd have to go to actual court to, although sometimes the parties can go back to mediation with the mediator to try to work out a problem. But at any rate, the idea is that's an agreement between the parent and the district. So creative solutions that you might not get through the IEP team process can come through the mediation process. Okay, now we're on to complaints. So when we receive a complaint, this is what happens, and this is what we let you know. And I guess we have some thoughts too about what you might do in each point of these. So anybody can file a complaint, if parent, an advocate, a community member. We've had a few from former staff members, sometimes from current staff members from a district might file a complaint. So can make for some interesting stuff. But when we receive the complaint, we take a look at it, we review it to make sure it's actually a potential IDEA issue. And if it is, we will go through the process of identifying the issues and assigning an investigator, and then you get an acknowledgement letter with us. We really, really, really want to get those out within 2 weeks of receiving the complaint, because we are on very strict timelines when it comes to IDEA state complaints. And occasionally, whoops, oh my gosh, there we go. Occasionally that it doesn't work that way, but mostly we are able to get the acknowledgement letter out within 2 weeks. The parent is supposed to, and I say parent, but know that I mean the complainant, because it isn't always a parent, but the complainant is supposed to, at the same time they send the complaint to us at DPI, to send the district a copy of the complaint. And sometimes that happens and sometimes it doesn't. I dislike tremendously when the first time a district is hearing about a complaint being filed is when you receive our acknowledgement letter. We don't, that's not ideal. But we're not going to say, oh, we can't do a complaint because you didn't let the district know. We're going to move forward, and we'll work with you forward from that point. So once the acknowledgement letter goes out, then the investigator is going to work with the district and the complainant to gather the information. And anybody can give us whatever information you think is relevant for us to make the decision. So can the parents. We will, if parents send us information, we're not about keeping secrets. So if parents send us something and it's not something you've seen and you want to see it, absolutely we'll share it with you, and vice versa is true as well. So we will take a look at that, and then we will come up with a decision within 60 days of receiving the complaint. And again, that is a very, very hard deadline. We very rarely miss that. It's why sometimes we move this process along really quick. One thing I will tell y'all, and I think I might talk about this in a bit later, but we just received, I think, complaint number 25147. So that is our 147th complaint for the 2025 calendar year. For some reason, we count them by calendar year. Last year, which was a really high volume complaint year, we didn't hit that number until December, like mid to late December. So we're like 2 months ahead of time. So we are definitely going to break our complaint records, yay us, and our numbers records anyway. And so that's partially why it takes us usually, you're usually not going to get a 60-day, a timeline or excuse me, you're not going to get a decision on a complaint much earlier than 60 days because we have many that we're working on. So investigators are right now working on, usually, I mean, like 3 or 4 at a time. And that's we prefer it to be 1 or 2 at a time, but we can't always decide that. So if we find that there's a violation, we will order corrective action. And that can vary. It can be things like, okay, well, oops, IEP team, you made a mistake when you were doing this part. Reconvene, talk about it again. Sometimes that reconvening involves, oops, IEP team, you made a mistake, and that meant the student missed something, or the student, maybe if there's lots of potential things, but sometimes that involves having a conversation about whether the student requires compensatory services to make up whatever was missed. So lots of ways that can go. Sometimes it's, wow, this is a bigger problem than just this student. And so district, you're going to have to do some training. And sometimes we're going to monitor for a year how you implement this requirement and make sure you get it right. Because our job in this complaint process is to make sure that when there's non-compliance, that we find it, that we fix it, and that we help you make sure it doesn't recur. So that's kind of the big deal with the complaints. And I keep moving the slide. I am so sorry, guys. Due process hearing and expedited due process hearing. I won't talk a ton about this, but you can see what the process is there. Again, it's different. It's controlled by the ALJ. There are timelines and deadlines, but the parties often ask for those to be amended, and the administrative law judge is able to do that. So again, if you receive a due process hearing request, that is definitely something that you should receive from the complainant, but we will let you know if the complainant doesn't. And at that point, you're going to work directly with the administrative law judge who will be assigned, and you'll get all the information about that. Sometimes due process hearing requests are expedited. Often that's because it involves, like, for example, a disciplinary situation where a student is at risk of their placement changing, even to the extent of an expulsion. There's those expedited processes, those really get pushed along faster, and there's good reason for that too. So, okay. So here is our dispute resolution data when we talk about complaints filed and investigated in the past several years. So you can see where the increase is. The blue bar here talks about the number filed. The green is the number investigated. So that difference there represents ones that either we couldn't take as IDEA complaints, they weren't, or they were withdrawn, or mediation, and the district and family went to mediation and they were able to resolve the issue, so the complaint was withdrawn. But you can see the number that we're getting is going way up. Now these were kind of COVID years, so that makes sense, 21 and 22, but you can see last year, the 23-24 school year, where we landed. Then the 24-25 school year, where we were. And again, this is school year data, so it's not quite lined up with our annual data, but I mean, our 25-26 numbers are looking like, we might need to extend the bar over 150 because we're getting higher numbers of complaints than that.
Yeah. And I just, Marge, I just want to
Yep.
add that the 22-23 numbers there are pretty close to what we were before COVID. We were, kind of high 80s, 90s, occasionally
Yeah.
100. That's kind of where we were pre-COVID. So 22-23 sort of marks a return to pre-COVID levels, and now you can see that we have just kind of exploded from there. So
right. And the due process hearing requests are up too. You can see that in that 24-25, we had 38 due process hearing requests. That's like really much increased. It used to be that we would get maybe 3, maybe 5. And very few of them would actually go through to hearing. And that's true. So there were only 5 that went to hearing and decisions. And then there were some that we were still waiting for resolution at the time that this slide was made. So, I mean, again, those requests are up as well. Again, most due process hearing requests, they get resolved early in the process. So there's resolution sessions, there's the potential for settlement. Most of the time, due process hearing requests never actually get to the hearing itself, but there's procedural steps along the way. So mediation requests were up in 24-25, and 62 facilitated IEP team meetings were requested in 24-25. So again, those are options that are available. I think the facilitated IEP team meeting is one that probably could be used a little more often than it is. It's good, again, proactive before things get too hairy, to get that third party in there. It can help restore trust or build trust in a situation where that's been affected for some reason. Oops, and we are not alone in the increases in amounts of complaints and things you're getting. This is the data from Cadre, which is the federally funded Technical Assistance Center for Dispute Resolution and Special Education. You know, like a lot of things that are federally funded, etc. This is it right now. We don't know what tomorrow will be, but for now, Cadre is very much, they've got great data to look at. And if you look now, different states, things happen differently. Like there are a lot of states where they get very few written state complaints, but they get a ton of due process complaints. You know, I mean, again, if you look, every single one of the metrics that they take here, it's on the increase, except for the resolution meetings held, which is probably not what we want to see. You know, like that would be better yeah. Anyway, if we had more of those, but you can see, I mean, again, it's nationwide. It's really very, very much that disputes are happening. Written state complaint activity for the nation. Again, you can see that, again, this is up. I don't need to keep talking about this, but I think that's my last slide on this one. Wondering if you all have questions at this point about, you know, the process of complaints that it might answer, or due process, whatever. We're happy to answer some questions, and then we can talk about some specific things in complaints.
And while we're waiting for questions to come in, I just want to go back to the beginning of the process a little bit and kind of talk about what it looks like for those of you that haven't had a complaint yet. Marge mentioned before that we have on our website, we encourage, we hope that parents will send the complaint or notify the district that a complaint is being filed when it gets sent to us. That often does not happen. So for many districts, unfortunately, the first time you'll be hearing about the complaint is when it'll be sent to the special education director and then also the superintendent or the district administrator. Essentially the acknowledgement letter stating we've received this complaint filed by X person regarding X student. And then it will also enumerate the issues that we're going to investigate. And that's also really key for us because that kind of defines the scope for the investigator. Because again, we have 9 investigators. We try to contain our investigations to what the parent is specifically complaining about. It's not just sort of an open book. We're going to investigate every aspect of the child's special education or IEP for every complaint that we get. That would just be probably not possible to do that with the number of complaints that we have. So you'll get that complaint acknowledgement letter, which will kind of also set the timeline, tell you who filed the complaint, outline the issues. We'll tell you who your investigator is. And it will also ask the district for some information, which is going to set some deadlines for when we need the students' IEPs that were in effect during the time frame that we're looking at. We can only go back 1 year from the date that we received the complaint, which is different than the due process situation or mediation or kind of the other dispute resolution options. So if something happened before, outside of that 1 year timeline, we will acknowledge it if we find out during the investigation that something happened during like outside of the 1 year timeline. We might write that up and just indicate, other allegations concerning, I don't know, adaptive FIAD services happened outside of the 1 year timeline, so we will not kind of be weighing in essentially on those issues. So we'll ask you for IEPs that were in effect. If there's any, evaluation records in question, anything along those lines, we'll also ask for that. And then eventually you'll get a call or an email or some level of outreach from your assigned investigator. Each of us, again, there's 9 of us. We all kind of have different ways of doing it. We are sort of independent in our processes, but aligned on kind of our goals and our outcomes. So then at that point, that investigator will kind of set up the remainder of the investigation as they want to handle it. The things that are the same amongst all of us is that we are all going to ask for probably more documentation, right? So the kind of form letter, it asks for, I believe it's just IEP records. But then from there, depending on what the issues are, I might need to see eval records, I might need to see behavior records, attendance records, maybe other stuff depending on what it is. Seclusion
We
restraint
Yeah, we
forms,
try
that
to,
kind of stuff.
yeah, we try to identify the documentation we're going to need. If we know that like an
Mhm.
issue is seclusion and restraint, we might
Yeah.
ask for those reports right up front too in the letter. Always the IEPs, well, unless it's like a case where there hasn't been an IEP
Right.
developed yet. But yeah, so we'll try to get whatever we need from you in the letter. But if we don't, we can ask for it later, and you can always send us things that you think will be helpful to us in this
Yep.
whether we ask for them or not.
Yep, 100%. And then the other thing that investigator is going to do is talk about the process for setting up interviews with staff. Almost all of our investigations have some level of interviews with staff. It could be 1 or 2. It could be 5, 6, 7, depending on the breadth and depth of the allegations, I guess. And usually those are, 20, 30-minute conversations with that staff member. Could also include the director or superintendent. Many districts will not hire attorneys to work on these things. You do not have to by any means, but many choose to. And kind of setting up, okay, how are we going to schedule these interviews? How are they going to take place? What are they going to look like? Are they going to be phone calls, Zoom interviews, those kind of things. So that's sort of what the beginning of the complaint, kind of beginning and middle part of the complaint process looks like, and sort of how we set things up. And then, as Marge said, we will also take anything that you want to show us or that you feel like for some reason we need to look at. If that's communications with the parent, I've received email, certainly text message records, audio recordings of various things. I've received security cam footage, all sorts of stuff. But also, we also get kind of more formal responses from districts where they choose to kind of almost like a legal document, sort of
Right.
like provide an official response, like this is the district's official response, which is great. Again,
Not
don't
required.
have to do that. Yep, and don't
Nope.
have to do that by any means. But there's just kind of different approaches that districts take and kind of how they want to kind of discuss the issues.
By the way, Mike gets the weirdest stuff.
Yeah.
If there's going to be some interesting, odd situation or materials that are going to be sent, those go pretty much directly to Mike. It's just kind of the way it works out. But anyway,
That has been true in the
yes,
last couple of years. Somehow I draw the short straw on some of the, shall we say, more interesting complaints. Now,
unique,
Marge,
complicated.
yeah, Marge is kind of our complaints coordinator, and so she does a lot of the intake and then also kind of is involved at like every level of the process. So Marge is often the one assigning me those strange complaints, and I feel like I'm being hazed at this point,
Right. You've been around. Yeah, I shouldn't still be
Yeah.
hazing you. Here's the thing. Um, It is actually pretty random. And usually we don't know how weird something is until after you get into the
So you
investigation.
actually dig in a
But
little bit, yes.
I will say complicated too. Some of these cases are really there's sometimes we get a straightforward complaint. We've got a couple of these right now where the question that's in front of us is parent is alleging the IEP wasn't implemented, and say it's about a speech and language, maybe a district that doesn't have a speech and language pathologist, so they've not been able to implement that IEP. Have you implemented the IEP is a pretty straight question. It's yes or no. Can you show us all these kind of things? And that's a simple one, right? If we find that the services haven't been provided, the corrective action is going to be, okay, well, get together, have an IEP meeting, talk about the compensatory services and where the student is and all that kind of thing. The reality of the situation is we know it's tough because the corrective action doesn't come with a speech and language therapist to start providing those services. I mean, we can't do anything
Right.
about staff absences. So, we understand that and do the best you can, but sometimes they're straightforward. I'm trying to think of the most number of issues personally that I've ever investigated. I had a complaint, I think, with 14 issues.
Yeah, I know I've had one with 8 or 9.
Yeah, so they can get really complicated.
We also will occasionally get one perhaps filed by maybe a community social worker we will occasionally get
Right,
one from, or perhaps a former employee that will name multiple students
right,
specifically. And in that case, we get maybe one of those a year, one or two. And in that case, we may assign multiple investigators just because of you kind of have to treat them all as individual complaints when they
right.
enumerate that many students. So um,
Uh,
I
I see
want
it.
to get
Oh, go ahead.
I wanted to talk about just two other things I want to hit
Okay.
really quickly, and then I want to get to that question from CC12 directors because that's a very
Yep.
good one.
Yep.
So as Marge mentioned before, when we get a complaint, if it is even remotely possible that this deals with anything special ed related, we have to acknowledge it and set a 60-day timeline. Now, if as on the district side for the director, district administrator, if this is the first you're hearing of the complaint, this can be very frustrating that you didn't kind of have a chance to state your case as to perhaps why this isn't the way things happened. But we cannot dismiss complaints once they've been acknowledged. The only way to kind of get off the complaint train tracks is for the decision to be issued or for the complainant to formally withdraw the complaint, no matter how the investigation is going. If we're in an investigation, it's just very clear these allegations are completely unfounded. We can't just stop. It has to go all the way through to the formal decision. And so I think that frustrates directors and district administrators at times, not because they don't want there to be a formal process, and this is a good thing for parents generally, but just because hey, we could have had a conversation about this. It didn't have to go this far. We felt kind of blindsided, and now you're saying we're stuck here. And unfortunately, that's just kind of how it works. We cannot make complaints go away without issuing decisions unless the complainant formally says, I withdraw. The last thing I want to talk about then is as far as outcomes of the complaint process, Marge talked about it, that there can be kind of no findings, and that's sort of the end of the complaint process. We may issue findings, and we will also prescribe corrective action, which can be student specific or district level. The one thing I want to highlight is just that under no under no circumstances is this a review of anyone's teaching license or any other licenses you may hold. It is not a review of anyone's employment status with the district. There are no punitive outcomes for individual staff members as a part of the IDEA complaint process. I just want to make that really clear. Obviously, people are concerned, confused, worried. Nobody wants to get a phone call from me. I completely get that. It's stressful as it is. I think we all do our best to turn the temperature down. But I've had when requesting interviews with teachers say, they've requested union reps to sit in on those meetings, which I will always allow. But that always tells me shoot, I wish I will explain it to them once we get to the call, that nobody's getting fired here. That's not a possibility. Really, it's about correcting processes and procedures and making the student whole if we find that they were owed something. So I just want to get through those, and then can we jump back into the question? So what number of due process requests are initiated by districts? That is a great question, and it's far
Very
less.
few.
Yeah.
Very few. Now, there are some very specific situations in which districts can initiate due process hearing requests. One of them is around the issue of a student who is that perhaps has had a behavior that is potentially, expellable, or and for some other reason looking at a change of placement, and you know that the behavior is a manifestation, and yet you need to have a short-term place. It's a manifestation. It's not an IAES behavior. It's not one of those few exceptions. That's a situation where a district can request an expedited due process hearing. Um, Again, we don't see many of those. I don't know why, but again, we don't see many of those. So it's much more often that the due process requests are initiated by parents or their attorneys. We do get several of them from attorneys. I see a few other questions. So you want to just
Yeah,
dive into
let's
those,
keep
Mike?
going. When a family files an IDEA complaint, what is the expected time frame for the family to hear from DPI? I know you guys are hopping. So as Marge said before, within 2 weeks from when we get the complaint in, which doesn't have to, we have a form that you can fill out, but it doesn't have to be on that specific form. But it does need to name the student, name the issues, not in citing statute or anything, but just say, hey, Johnny, I have reason to believe he isn't getting his reading services. And we'll kind of translate that for you into regs and statutes and all that kind of stuff. But it has to name the student, name the possible issues, and then also be signed. We can't have anonymous complaints come in. So as long as it has all three of those criteria, I think that's it, Marge, is it the three?
Yeah.
Then we will acknowledge those. And that's kind of when the family will hear first from us, unless there's kind of confusion or we need further
Yeah.
information uh, uh, to name those issues, and Marge takes care of that. So
Yeah, usually, I mean, again, most times it's relatively clear and we can move forward, but
yeah,
there are times when I need to seek clarity from the complainant. So I will reach out to them early and let them know. And if something is not a complaint we can take, I reach out to those folks as well so that they understand why they're going to get a letter from us that says, sorry, we can't do this. So yeah, it again, we'd love it to be faster, but there's nothing that prevents the complainant or the district from contacting us if we haven't contacted you yet once that acknowledgement letter has been received. I mean, if you haven't heard from us, it's probably just because we're busy, but again,
right.
reach out. We're all accessible, and we'll do what we can do.
Yeah, and in that acknowledgement letter, it will have the name of your investigator, and then also I believe their email and their phone number. So if for any reason on the district side, if you have questions, concerns, if you have a question, the second the acknowledgement letter comes out, I've gotten phone calls,
Yep.
For that too. So that's totally fine.
Yep.
Please reach out and ask us questions.
Yep. A question that came into on the parking lot, districts clarification was requested. Districts can contact a parent to try and arrange mediation after a complaint is filed, and the answer to that is absolutely yes.
Absolutely.
A district can contact a parent to try to arrange mediation. Sometimes it's just a matter of, hey, I need to have a conversation with this parent. I, as the director, wasn't aware maybe that there was an issue or that it had gotten to this point. And oftentimes you all as directors are able to intervene in situations like maybe at the building level or something like that, and the parent, and it can get resolved to the parent's satisfaction. They withdraw the complaint. So absolutely, you can do all the things even if there's a complaint going on, and y'all are pretty darn good at helping get those things resolved, so we encourage it very much. Yeah, so that was one of the questions.
We've got one in here. If the complainant does not want the compensatory services, is it done? This is an interesting question. So the first thing I want to say is usually the way that we prescribe compensatory services in the corrective action, if we find, I don't know, reading services were supposed to happen twice a week and they only happened once a week, so just I'm making something up here. Usually the language in the complaint decision will require the IEP team to reconvene to determine whether and to what extent compensatory services are owed, because the guidance from OSEP says that not in most circumstances, like minute for minute compensatory services are not owed and not the way that it should be calculated. It should be a discussion about whether the student is making progress towards their IEP goals and the general ed curriculum. So that's where we will direct the IEP team to have a conversation about kind of whether and to what extent is the student still making the progress we expected them to, or maybe more. Hopefully that would be wonderful. Or if not, kind of what do we need to make up here? We do have circumstances where maybe the relationship between the family and the district is particularly contentious, or the violations were particularly egregious. And then we may dictate and give an actual number, or say that compensatory services are required, you figure out the number and bring it back to us. So in those situations, I guess that question to me jumps out more as a possibility in that situation of whether and to what extent, where the parents would be part of the IEP team. And at that point, they may voice, no, we actually don't feel like we need these compensatory services. And then that's the decision of the IEP team. And you can bring that back to us, and that's totally acceptable. If we are determining a number of compensatory services or stating there must be compensatory services, we're not in a situation where I think the parent would waive them, but I also I don't know that we've had that, Marge. I guess if the parent doesn't
Yeah,
want them.
yeah, it happens. It happens in the context of complaints. Another place where we'll see it happen a lot is when y'all are going through your procedural compliance self-assessment,
Sure.
and you'll have one of the errors where we say, convene the IEP team meeting, consider compensatory services, and the parents say,
Yeah.
yeah, we
We're
don't need
good.
to do
Yeah,
that.
we're
We'll
good.
just
Yeah.
fix the thing. So it's along those same lines. A parent can say, no, you can't,
Yeah.
you do your best to be creating a service that's meaningful for the student and the family, and it's you can be creative. I mean, it doesn't have to be
Yep.
OT services. I mean, again, you can be very creative, but if worse comes to worse and you just can't come to agreement, parent doesn't want them, parent says very clearly, I don't want these, let's talk and let's figure
Yeah.
that out.
Yep. I think we were going to go till 11:50. So I think we maybe have time for one more question.
Okay, this one, I don't know if Paul Sherman, are you still here? Okay. As WSEMS doesn't get involved until, this is a facilitated IEP team meeting question. As WSEMS doesn't get involved until an IEP is established, what suggestions can you offer for districts and families in an evaluation process that would benefit proactively from a facilitated or third-party guidance at an evaluation meeting? Thing one I'll say is, I need to find out more about the part where you're saying WSCMS won't get involved until there's an IEP. So I can look into that. We can get back to you. But I think, IEP facilitation is something that WSCMS offers and provides, but it doesn't, if you've got someone in your district, some districts have people who do IEP team facilitation. It doesn't have to be someone from the service. It can, and sometimes there's a real benefit to that, but it's not unusual for maybe, especially in initials, for someone who's not necessarily going to be involved in the day-to-day serving of the student to be involved in the evaluation process, maybe as a diagnostician or whatever, who specialize kind of in those initials. And not every district has that as a resource. I know that, but I think it's always good to have someone whose job it is to kind of be monitoring the process in an IEP team meeting, making sure things are moving forward in a direction. You know that you'll get the recommendation from us often that we suggest an agenda, that sort of thing. And that can help. Yeah, but I will find out about the question about WSEMS and what is the first time they're going to be able to get involved. So thank you.
Yeah, and then the other piece is if it's later in the evaluation, like the district has made their determination, if the parent doesn't agree, depending on how you approach the conversation, letting the parent know about their right to an IEE, I think can help some of that. Not in a way of like, well, you can go elsewhere and figure this out. But if it's, hey, we stand by this evaluation and the work that we've done, you're entitled to a second opinion, if that's what you're looking for, to kind of ensure that this has been done correctly. That's a right that parents have, and you can provide that information. Again, as long as that conversation is approached from a certain direction and not the other one. that can sometimes help as well.
Yes, there's so many things we could talk about. We love talking about this stuff. We absolutely love talking to all of you, but I think we have hit our time.
Yeah,
All
I think
right.
that's it.
Thank you so much for joining us. And I know we appreciate the information. We also appreciate seeing your faces every year. Just in the event that we find ourselves in one of these situations, it makes it an easier process to know that we will be speaking to the friendly face on the other end of the line. So thank
Yeah,
you so
we're
much.
real people, not compliance robot cops. So yeah,
Thank you. Have a good day.
thank you.
All right. Thank you everyone for joining us. Our next meeting will be on November 12th. It is a 3-hour. It's from 9 to noon on November 12th. Just a reminder that you do need to register for each month separately, and the registration link is at the bottom of today's agenda. You will also receive a follow-up email after this meeting. And again, once our YouTube video is posted, recording of the event, we will have timestamps right in that agenda where you can find each of the pieces of information. Also, if we were provided resources by any of the speakers, those will be linked into the agenda at that time. But in November, we will be talking about serving students with visual impairments and a teacher rubric for that. We will be talking about the upcoming data snapshot that will be coming up in December, and we will have some fiscal updates. So thank you so much for joining us, and we hope to see you next month.